What's up, everyone out there in YouTube world, Facebook world, social media world, the world, wherever you're watching this from? Welcome to another edition of Musings with MGL. I am your host, as always, MGL. Got one hot off the presses for you here today. I can't tell you how many times a week I get phone calls from people asking about marijuana use and firearms, especially if you live in a state that either allows full-on marijuana use or medical marijuana. Like here in Florida, we allow medical marijuana. So you have medical marijuana states, no marijuana states, and then you have full-use marijuana states. So because of that, at least once a week, I get phone calls or emails from people wanting to know, hey, can I have a firearm with marijuana? Well, right now, the current state of the law is no. If you scroll through some of my previous videos, you'll see I did a video on this. I'm not going to go through the entire thing here again today. But the essential thing is marijuana remains a felony and a prohibited substance by the federal government. So it doesn't matter what your state says, whether it's legal, not legal, whether it's medical or not. It doesn't matter. The federal government considers marijuana to be a schedule narcotic, and therefore anybody who uses marijuana, regardless of what your state law says, is violating federal law and is a prohibited person from possessing firearms. You can't get a concealed carry permit, you can't possess firearms, you can't buy them, etc., etc. So here we go, though. Breaking news, because we all knew that this was eventually going to come up to somebody, but here we go. Breaking news. Marijuana users rejoice. So marijuana users have a constitutional right to own firearms. Judge rules. Supreme Court case, New York State Rifle and Pistol Association versus Bruen set new standards for firearm regulations. This is important because I did another video that's going to be coming out here soon as well. This one was just kind of breaking news. So I got another one that's going to come out where I'm going to talk about restrictions on people with domestic battery injunctions or domestic violence injunctions. That was recently thrown out as well. So this is another ruling under this new Bruen ruling that came out last year by the Supreme Court that is going pro Second Amendment way. So a federal judge in Oklahoma ruled Friday that a law barring marijuana users from owning firearms is unconstitutional. The ruling is the latest challenge to firearms regulations after the U.S. Supreme Court's conservative majority set new standards for reviewing the nation's gun laws. U.S. District Judge Patrick Wyrick in Oklahoma City dismissed an indictment against Jared Michael Harrison, who was charged in August with violating a federal law that makes it illegal for unlawful users or addicts of controlled substances to possess firearms. Harrison's lawyers had argued the portion of federal firearms law focused on drug users or addicts and was not consistent with the nation's historical tradition of firearm regulation, echoing what the U.S. Supreme Court ruled last year in a case known as New York State Rifle and Pistol Association versus Bruen. The case set new standards for interpreting the Second Amendment. And this is the standard here that everybody's talking about and all these judges are relying on, which is in Bruen, the Supreme Court said that unless a gun law, an anti-gun law, is rooted in the nation's history, in other words, if it's a historical firearm laws that has basically been in place before and at the time that the Second Amendment was created, it has to be a historical tradition of firearm regulation, then they can regulate it. If it's not, if it's something that's kind of brand new because, society changes or whatever, and so we want to add all these things to it, then it's no longer valid in the Second Amendment. And that's the language and the concept that all these judges have been using to throw out all of these issues. Of course, federal prosecutors argued that it was traditional because we have a long-standing history of disarming people who are presumptively risky persons, namely felons, the mentally ill, and the intoxicated. So the federal government's prosecutors and position is anybody who uses drugs, even marijuana, are presumptively risky people and should not be having firearms. The judge, Wyrick, agreed with Harrison's lawyers, ruling that federal prosecutors' arguments that Harrison's status as a marijuana user justifies stripping him of his fundamental right to possess a firearm is not a constitutionally permissible means of disarming Harrison. The mere use of marijuana carries none of the characteristics that the nation's history and tradition of firearm regulations support. And then here's a little tagline. The decision comes after the New Orleans-based 5th U.S. Circuit Court of Appeals ruled Thursday that a federal law barring people with domestic violence restraining orders have a constitutional right to own firearms. I did a video on that as well. Check it look through my channel. It'll be posted, and then I'll give you the history of what happened with there as well. So the bottom line is a federal judge, but it's just a lone federal judge has declared it unconstitutional and threw out a criminal indictment. That doesn't mean that that's now the law of the land. That doesn't mean that all of a sudden, if you smoke marijuana or have a medical marijuana card, that you can all of a sudden start possessing firearms. You can run down to your local firearm shop and buy a firearm today. You're still not going to be able to do that, okay? This is one ruling by one judge. I don't know if they're going to appeal it or not, because I think that they may be afraid that if they appeal it, that it will go up to the Supreme Court and the Supreme Court will uphold it. And so what they may do is just leave it sit and say this only applies to this one guy, and therefore it's not, it doesn't apply to your state or doesn't apply to anybody else. So I hope they do appeal it, because I'd like to get some of these to go all the way up to the Supreme Court and see how they would rule. Because if the Supreme Court's going to be consistent with their previous ruling, then they may throw out the bump stock ban, which was thrown out about a month ago by a federal judge. They may throw out the risk protection order, which was thrown out about a month ago by a state judge in New York. They may throw out the domestic violence restriction. They may throw out the marijuana restriction like the judge wanted to do in this case. So it'd be interesting to see what happens with this one. So stay tuned to the channel and keep watching. I'll be doing follow-ups to see if this one goes through the appeal process or what the rule is. So good news. Even if you hate people who smoke marijuana or drug users, but if you're a Second Amendment absolutist like I am, there is no period, or there is a period at the end of shall not be infringed. There's no comma. It doesn't say shall not be infringed, comma, unless you smoke weed. Like there's no comma there. There's no buts behind it. It's a period. So I do not believe it's constitutional to take people's Second Amendment rights today because you believe that they are an unlawful user of a controlled substance, especially marijuana, which is becoming obviously an accepted form of recreational narcotic. So this is just the first step. It's just, again, it's one ruling by one judge. Do not run out and think that now all of a sudden you can smoke marijuana and possess a firearm, because it is still illegal until either DCA, which is a district appeals court, or the U.S. Supreme Court rules on this particular ruling. So just keep in mind, like, share, subscribe, click the bell notifications, ding, 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 so you will get notified when I keep you updated on when this gets appealed or what new existing things are coming. And so thanks for watching. I'm going to end it here. As always, stay safe, stay healthy, stay vigilant, and as always, carry on.